for those of you that don't know me, I am Jennifer Burns. I'm the head of the Science and History Division here at Central. And we are super excited to have Susan Tull here, a partner at Finnegan, based in Washington, D.C. And she's quite the catch. Neil and Spruce from the PTO said, "How did you get Susan to come here?" And I said, "I asked her." And she's just super nice. So thank you all for coming. Thank you for celebrating with us. And Susan Tull.
Thank you, everybody, and I'd like to thank Jennifer for the introduction and for asking me to be here. And I'd also like to, again, just recognize that, the fact that we're here for the 20th anniversary of the Carlson Center for Intellectual Property is a pretty amazing event, and to thank the center for all of the work that they do in terms of working with inventors and entrepreneurs and bringing some of the esoteric work that we do, bringing it into the community, bringing it to Rochester, and helping people take their inventions and their dreams and making them a reality. So with that, I'm going to jump into my talk. It focuses on the patenting of medicine, which is an area that I've looked at a lot in the past several years. So just briefly, I'll be talking about what is a patent. Why are we here? Why are you interested in patents? A lot of you may already know the answers to this, but we'll touch on that briefly. Some of the history of medical patents. What is the value of a patent? Some of the current events and the medical patents in the news that we're hearing about. Hurdles to obtaining patent protection in the medical field right now. And then sort of future looking, we've seen a lot of activity in the artificial intelligence space for medical patenting, and what are some of the issues facing artificial intelligence technology. So first question, what's a patent? So our history of patent law in the United States actually goes all the way back to the Constitution. So in the Constitution itself, Section 8, Clause 8, it states that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's where our copyright protection comes from, and that's where our patent protection comes from. So this isn't a new concept that came out of corporate interest or anything else. This goes all the way back to the very founding of our country, where we recognize that innovation, that entrepreneurs, that people putting in the research to come up with these ideas, to promote our economy and our arts and our literature and everything else, was something that the government wanted to stand behind and to recognize. So in terms of what is a patent today, it's a legal document that's issued by the United States Patent and Trademark Office. You have to include a full disclosure of what you've invented, and you have to tell the world what it is you've invented and give them a description of it, and you have to tell people how to make and use your invention. That disclosure, telling people how to make and use something new, is what gets you a monopoly on your invention. And the monopoly is you are the only person, and it's typically for 20 years since you filed your application, that can make, use, sell, offer for sale, or license your invention in the United States. And you may hear in the news that, we don't like monopolies. Monopolies are bad. We want free capitalism. We want free commerce. And so the idea of the patent is that invention and entrepreneurship is so fundamental to our country that we are willing to give this limited monopoly to people in exchange for them putting in the time, the effort, the money, everything it takes to get a patent in this country. And so that's our trade-off. It is, your patent's only valid for a limited period of time. It's typically a 20-year life period from the time that you file your invention. It only protects your invention in the United States. So other countries have their own patent laws and their own patent systems. So for example, if you come up with an idea in the United States and you obtain a patent in the United States, unfortunately, if you don't get a patent in China, if you don't get a patent in Argentina, somebody can then take your invention and use it and make it there. And that's something I think people have heard about a lot, where the phrase knockoffs comes in, or people are taking the invention. But all of those countries also have their own patent systems, and if you have an idea and it really takes off and it's valuable in another market, you can get protection there. And that being said as well, if people don't have a patent in the United States and they're using a product somewhere else, you can feel free to use it here. And the rights are freely transferable. And that means if you come up with a great invention, you can license it or sell it to somebody else. And I think we heard a little bit earlier today about how really sort of that intersection of events with Xerox came to be, and that we had the brilliant idea and we had the company that was willing to make the investment. And I'm assuming that there was probably a transfer or assignment of rights somewhere along the way to Xerox, so Xerox could become the corporation that it is today. Okay. So what can be patented? And I throw in a little bit of the statutes here. You don't need to know, well, you don't need to worry about anything I say, but you certainly don't need to worry about the numbers. But I'm a lawyer, so we always have to cite the statutes. And so there's a statute that lays out what can be patented. And it's machines, compositions of matter, articles of manufacture, and processes. So it's basically anything that human hands have touched or human hands have built. Okay. What's not patentable? Laws of nature. I can't patent gravity. It exists. I can't patent natural phenomenon. So for example, I couldn't, if I was the first person to figure out how the human kidney worked, I still couldn't patent the functioning of the human kidney, because then you would all be infringing my patents and I could sue you, and we don't want that. Other things that are considered to be natural phenomenon, going back to, this was big when I was in high school, Dolly the cloned sheep. You can't patent cloned animals because those animals are found in nature and you have just made an exact replica of it. So you can't find a plant somewhere that has great curative properties and patent that plant. You can perhaps patent a way of extracting the essential oils from it, a way of growing it artificially, but the plant itself, it's part of nature, and you're not allowed to say, hey, I'm taking something in the natural world and taking it from the public and making it my own. That's not allowed. That's part of that trade-off. If it's already out there in the world, you don't get to take it back from everybody else. And then abstract ideas. A lot of this comes from laws of physics, laws of science, mathematical equations, and this balance is that there are ideas out there in the world that are so fundamental to forward advancement that if you start to say, I own the right to a mathematical equation or a law of physics or a law of science, then you're really blocking the entire industry from growth, and we don't want that. So the courts have stepped in and said, well, here are a couple of areas that we're not going to allow people to get patents. Okay. In order to get a patent, and I believe it was Neil and Spruce have touched on this already, and there are some great materials in the back there that go through what it takes to get a patent and some of the steps to get a patent. But the general idea is that you have to come up with something new. And at present, it has to be new in the entire world. So if it's already made in another country, if it's sold in another country or somewhere else in the United States, if it's written down in an article, if somebody else has a patent on it, that's not considered to be new. It has to be, it's not obvious, and this is a tricky concept, and it's one that we spend a lot of time battling over in court about whether or not something is obvious. But the idea is I can't take an idea that somebody already has and then just make I call it a duh improvement. You know, it's the type of thing that if everybody who worked in the field said, well, I came up with that idea too, then you shouldn't be able to get a patent on it and then be able to force everybody else away from your invention and say, no, you can't use that, I came up with it. And then as part of this exchange, what do you get in exchange for getting the patent? You have to be able to describe your patent, and you have to provide a description that allows other people in your field, in your technology, to make and use the invention. Because again, if you're going to be allowed to keep other people from using your idea, you have to give something back to the public. And it's this description of your idea is what you're giving back. So I'd like to go through some of the interesting patents that have come out over the years, and these are some of the breakthrough medical technologies, as well as some of the interesting patent disputes that have arisen out of them. So here's a brief timeline, and patents have been around well before the 1930s, but The first X-ray patent was in 1934. The catheter patent, which I'll discuss in a little more detail briefly, was 1943. Penicillin, something we still use today, the original patent for penicillin, and that's the method of making penicillin, not for the naturally occurring penicillin itself, was in 1949. The hypodermic syringe was 1967. MRI, a device that we still use today. The first MRI machine was patented in 1974. The laser phaco probe was in 1988. Implantable pacemaker was 2004, and this was a temporarily varying pacemaker. I'll talk more about the original patent on pacemaking technology in a little bit. And then the 8 millionth patent that the Patent Office granted was a medical device as well, and that was for a visual prosthesis. So medical patenting has a long history, and it's one that continues through today. And you can see that there's been a growth in medical patenting technology over the past 10 years. So we end with 2019, and it was just through where we are in present day. But really, there's been a significant increase, and these are just medical devices, what the Patent Office classifies as medical devices. This doesn't necessarily even capture all the software that's directed to medical technology. It doesn't cover pharmaceutical products. This is really just pulling a limited subset based on how the Patent Office classifies patent applications, just to give you an idea of how many patents are ongoing in the medical device industry. So touching a little bit more on the catheter patent, this one I thought was interesting because the patent you see here is to a Paul Raish. And I don't know if anybody in the room has heard about the Foley catheter. You don't hear about a Raish catheter. So there was actually a dispute over who was the first to invent the catheter, and Raish won the patent dispute and got the patent right. But in fact, because Foley made a better catheter and one that was better known to doctors, he really gets the credit for the catheter in the public's mind. But in fact, the first patent on the catheter was to somebody other than Foley. And I don't know if anybody's heard about the Tesla-Edison debate over the light bulb, and that's, I think, a little bit more broadly known, but it's a similar story where perhaps somebody else came up with the idea first and had the original patent on it, but because somebody else did a better job of commercializing it, or perhaps came up with a way of commercializing it and making the product better, they're the ones we all know about today, just like with Edison and like the Foley catheter. The method for penicillin, so this was just going back to 1949. It's always shocking to me to look back at some of the historical patents and think that, you know, what penicillin did in terms of, allowing people to survive surgical procedures, allowing people to survive illnesses. And this is still a fundamental technology that's at the core of our medical practice today. And if you want, you can go online and you can pull up the original documents from 1949 where they describe their invention. So that's a little bit of the patent nerd in me. The pacemaker, so this is for the first implantable cardio pacemaker, and that goes back to 1962. And if you think about it, we still have pacemaking technology here today. And so the first patent for 1962 was to Wilson Greatbatch. And so he was actually, his innovation of the cardiac pacemaker was selected in 1983 by the National Society of Professional Engineers as one of the two major engineering contributions to society in the previous 50 years. And in 1986, he was inducted into the National Inventors Hall of Fame for this invention. So a technology that goes back to 1962 is still being recognized, not just 20 years later, but decades and decades and decades after. And in fact, there was a patent fight in the 2000s where the first implantable cardioverter defibrillator, which is akin to a pacemaker but serves a slightly different function, but it's implanted into the body and it helps you regulate your human heart, was invented by somebody named Murawski. And he was very successful. He developed a portfolio of patents that he licensed out to major companies. He licensed them out to Boston Scientific, to Medtronic, to Guidant, to, the really big names that you hear about in terms of medical device products. But what happened was these companies started with his portfolio of patents, and they had products out on the market, and then they started to develop new products. And they said, our new products, they don't fall within your patents. We don't owe you any money for them. They're not part of the license agreement. And so he, and ultimately became his estate, wound up suing several of these companies. And so that this, what started off as a very small group of inventors with Murawski as the front, ultimately obtained a $309 million settlement from Boston Scientific for violating the license agreement where they licensed his patent portfolio. And so all of this technology stems from the original pacemaker in 1960 to a new portfolio of patents that was for a new invention of this technology in the 90s and the 2000s. And after about 10 years of litigation, it resulted in one of the largest settlements for medical devices ever. The MRI machine, that goes back to 1974, and that's the date that the patent issued. And this is for an apparatus and method for detecting cancer in tissue. And as you can see, this is a little bit different than what we're used to seeing for our MRI machines today, but this is the core of the technology. And this was invented by Raymond Damadian, or I'm probably butchering that, but he had a very small company called Phono Corporation, and it made MRI imaging machines. And this was his patent, and he believed not just in the technology, but that open MRIs would be the best way to get an MRI, as opposed to an entirely closed tube, which some of the other companies were doing. And his patent was focused on the more open MRI. And so when people made closed MRIs, they didn't necessarily infringe the patent, it was fine, but then everybody else started to realize, hey, open MRIs are way better. Who wants to be in this metal tube while you're going through the MRI? You'd much rather have an open space. So the whole market started to shift in this direction, and he filed suit against them. So he filed suit against Hitachi, Johnson & Johnson, Philips Electronics, Siemens, and General Electric. And ultimately, he didn't prevail against all of them, but he did prevail against some of them. So the companies all said they developed their own scanning technology, they didn't need to use his technology, but really, I believe all of the companies settled, and so it was for an undisclosed sum of money, but there was one ruling out of a court against GE where GE had to pay him $128 million. So GE, $128 million, and then settlements with Hitachi, Johnson & Johnson, Philips, and Siemens. So this is another example of how one person with an idea, a small corporation, can go up against the big companies based on the strength of their patents and their patent portfolio. And then jumping a bit ahead to what I think will be some of the future technology that we'll be seeing, we're seeing a lot of artificial intelligence in both medical devices, medical imaging, and drug development. And so this is the idea of using the computer and the software that's driving the computer to teach itself. And one area that they're doing this is in things like cancer detection. So they will take a bunch of images, known images of patients' tumors or malignant growths on their skin, and they will provide the diagnosis to the computer. They'll show the computer the image, they'll tell it the diagnosis, and the technology is such that the device can actually start to predict with the same accuracy as doctors whether or not an image it's never seen before is malignant growth, is cancer, or something else. We're also seeing in terms of the pharmaceutical side of it that they're able now to take the artificial intelligence and predict what chemical combinations will work for what illnesses and what the potential side effects will be. And so these are all things that people could do and have done for years, but just the computing power is reducing the speed or reducing the length of time it takes to reach these inventions tremendously. And so hopefully we'll start to see some of this actually making its way into the public and doing the public good with some more breakthrough inventions and more breakthrough pharmaceutical products. Okay. Another area we're seeing a lot of, it's abbreviated as SAMD, it's software as a medical device, and that's a lot of your phone helping you with your healthcare management. And it runs the gamut. It runs the gamut from your Fitbit watch tracking your steps to communicating with the app on your phone and then telling you, hey, you probably need to walk around a little bit more today, you haven't moved, to this is a patent where it's actually analyzing your blood sugar level without, part of the invention is that you don't have to prick your finger. It's based on a reading that you do from a patch on your skin, but then it's also interfacing with your phone, and your phone is recommending whether or not you need insulin, and then potentially in the future, your phone will then, if you have an insulin pump, interface with the pump and deliver the right dosage to you. So it's essentially removing a lot of the manual steps that people have to do today and putting it into the technology and giving people a lot of the power as well. Because if it's on your phone, if you can read it, if you can see it, that means that you can be involved in the decision-making process as well. Okay. And the last is augmented reality. And you've heard about virtual reality, augmented reality. Augmented reality is taking what you see and what's available in the real world and then applying another layer on top of it. And I think the most popular example of this is the Pokemon Go game. So if anybody here has played it, you walk around and you see, you look at your computer, or you look at your phone or your iPad, whatever you have, and your camera's on, and so it's showing you what you're seeing. You know, if I were playing it here, I'd see this room, I'd see all of you sitting here, and then all of a sudden a Pokemon Go character would appear on my screen, overlaid on one of you, and I could play and try to capture the Pokemon or whatever it is. But it's that layering of some form of virtual reality or animation on top of what you're actually seeing and what's actually being captured in an image. And they're using this technology now in medicine. So what they're doing is, for example, this patent is to help guide needle insertion during surgeries or at other points where infusions are needed. So they're taking the physical image of what's being shown in the real world, and then they overlay this path that the needle should take for the doctor or for the nurse who's inserting it. There are similar technologies that are being proposed for surgery. You know, how can you make the best cut in a surgery? Well, if you actually have this virtual diagram, if you're looking at an image of the patient's skin, and then laid over on top of that is the virtual diagram of where you should cut, how far you should cut, and everything else, and you as the surgeon can just follow that along, it helps reduce, hopefully at least some of the riskiness that would accompany surgery. So these are some of the areas that we think that we're starting to see patents filed in medical fields that are new, and we think we'll see more of it as the technology develops. Okay. Additional areas that we're seeing a lot of innovation in, Internet of Things. I don't think you can get away from the Internet of Things in any field, but certainly in the medical field, wearable health tech. And this is an interesting market for us because we're seeing companies that aren't typically medical companies, companies like Nike, for example, going into the medical device space because they've developed technology that, for example, can monitor your heartbeat. You know, your Fitbit watch has a heartbeat monitoring function. Now, what if they can take your heartbeat information and send it to your doctor if there's an issue with your heart, if they detect an irregular heart rhythm? All of a sudden, they're going from a fitness company to a medical device company, and we're seeing the opposite come as well, where you have these large medical device companies that really haven't developed small wearable products now looking to move into that industry. Robotic surgery, bioelectric signal processing, remote and telemonitoring, and so that's again using a lot of times your smartphone to help send your signal to your doctor. They're also now moving into technology which would allow you to take photos with your phone, and then your phone would send that out. It would either send the information to your doctor, or in the case of artificial intelligence, your device itself could be making the diagnosis for you. Organizing patient health information, you hear about this a lot, where doctors and facilities are so spread out, and maybe you're seeing one specialist in one hospital for an issue and another specialist over here, and the patient records aren't always transferring, and sometimes that results in providing prescriptions that result in adverse events, or a doctor just not having a full medical history. So organizing patient health is actually a big area as well. medical imaging, as I mentioned, and diagnostic technologies. And then there's an area that is known as biologics and biosimilars, and that's one that I will fully admit I don't have a ton of knowledge in. I tend to stay more on the medical device side. But this is a new area that we're seeing in terms of pharmaceutical development, where it's not the traditional chemical products that are being used for the pharmaceuticals, but also involving bioagents as well with that. Okay. So with all of that, not all patents are created equal. The patent office does an amazing job of working through the inventions and seeing what is or is not patentable, but they work within a set of rules and regulations that are set out by the statute and by the patent office itself. So you can get a patent, and people get a patent on any number of things, but that doesn't mean that it's actually going to revolutionize the world. One example I like to give, and it's one that I sometimes use at my house, but I admit it doesn't revolutionize the world. If you have seen the trash bags that come out around the fall, and the trash bag is orange with a pumpkin face on it, that is in fact patented. But yeah, I mean, hey, I bought it, so somebody made money off of it. So these are just a couple of examples I like to throw out, and one of which is for a life expectancy timepiece. And this is actually a watch that is supposed to predict when you die, and it tells you it. There is a running countdown on the watch to your date of death. Now, there is actually some technology behind it where you provide all of your patient records, your family history. So in terms of predicting your date of death, there is, I think, a medical basis for it.
I'm sorry, ignore that. It's just an announcement.
That's fine. I can talk over everything, don't worry. Right. So I mean, I think that there is some scientific merit to the predicted life expectancy. It's just like, when you look at your family history and if you've had certain illnesses, it's the same thing your doctor does, but I personally would not want a watch that was literally counting down my days, hours, minutes, and seconds left on this world. This one I don't think really took the market by storm. And then one you may have heard of comes out of the Theranos company. And so there's actually a documentary on HBO right now called Out for Blood that's very interesting. But there's essentially a woman, Elizabeth Holmes, who founded a company, Theranos, and she raised billions of dollars based on her claim that she was going to be able to create what is essentially a portable drug and medical lab. So when you have your blood drawn and they send it out to test for various conditions, if they, basically anytime you have your blood processed and it has to go to a lab, her company's claim and her claim was that she could create a small portable device, basically the size of, I think, an ink printer, and that you could take that out. She was particularly pitching it to the military. You could take that out into the field with you and be able to diagnose different conditions, do a full blood workup on the field, on the spot with this tiny little device. And obviously that didn't happen, which is why we're talking about it today and why there is an HBO documentary about it. But, she did obtain patents for this technology. And she did. I mean, she had world-renowned experts working at her lab on this technology who were submitting statements to not just to the patent office, but to everybody about how this invention worked, how they had had success on doing it, how all of this processing was possible, and they were just months away. And so at one point, Forbes valued this company at $9 billion. She raised millions upon millions in venture capital. She had government buy-in, she had political buy-in, she had entrepreneur venture capital buy-in, and ultimately it turned out that everything that she said they had done was in fact not true. And that while they had been able to do some processing, sort of shorten the steps for the blood work analysis a little bit for certain conditions, obviously they did not have a small portable lab that you could take out onto the field with you, or else we wouldn't be talking about it today. So this is just an example of a lot of what she did was she took the patent portfolio and pitched it and said, well, look, we've got these patents now. And so in addition to having the buy-off, or not the buy-in from scientific experts in the field, she also pitched her patent portfolio and said, we have this technology and we're the only people that can use it. So if you don't buy in with me now, if you don't invest, you're going to be left out in the cold. And it was a very compelling argument because they got millions upon millions of dollars for it. So patents are a wonderful asset and they're a wonderful tool in helping companies monetize their business and getting venture capital startup. But sometimes buyer beware. And so that leads me to what is the value of a patent? And, patents run the gamut. It can go from the pumpkin trash bag that I buy at the CVS for, $1 for a bag of trash bags to potentially nothing to million and billion dollar portfolios. So these are just some examples, and these are obviously the sexy numbers because that's what makes it interesting. But 12.5 billion for Motorola patents, 4.5 billion. I mean, Microsoft bought AOL patents for 1.1 billion, and this is obviously, I think, a slightly older portfolio sale since nobody's really talking about AOL too much anymore. RIM portfolio. So the RIM portfolio went back to the original BlackBerry technology, which is now out of date in light of Apple, but all of these portfolio transactions were based on the strength of the patent portfolios. And then obviously Kodak, which I think a lot of people here are familiar with, 527 million for the portfolio sale. And those were cases where the patent portfolio was sold. There are also any number of instances where you think that somebody is using your patent, they won't agree to license the technology from you, so you do have to sue them in court. And these are judgments and settlements that arose out of litigation. And in particular, the one in the middle, that 309 million, was the Murawski versus Boston Scientific judgment that came out of the Pacemaker case. So again, these are the higher end. You don't tend to see quite as many of these numbers in the medical device field. You see significant numbers, but they tend to be more in the tens of millions instead of the hundreds of millions or billions. Pharmaceutical products, drugs, those tend to be in the hundreds of millions, just because if you think about a successful drug, take Viagra, for example. I don't know if this is true, but when you read about it in the Wall Street Journal, the phrase they use is that a successful drug like Viagra makes $1 million a day in profit. Yeah. So if you can be the only company that's allowed to make and use that pharmaceutical product, you can see how you could easily rack up in the hundreds of millions of dollars if somebody is taking your technology without your permission. So in terms of, those numbers are great, but it's a very, very tiny fraction of patents that actually arrive at those numbers. So what do patents do more frequently in the real world? Well, they provide you with a competitive advantage. If you have a patent and you think somebody else is moving into your technological space, you can tell them, hey, I have a patent, and you can send them a cease and desist letter. And a lot of times a cease and desist letter just says, here's my patent, here's how I think you're using my patent, please stop. And sometimes that's enough to get a competitor to move away from the product they were developing, to move out of your market, and it allows you to be, again, the only person in that market. Defense versus offense. So you can, as I said, offensively send a letter out to somebody and say, hey, I have a patent here. If this persists, I'll have to talk to a lawyer, or you'll hear from me again. But it's also a good defense. If you're a competitor or somebody else is in the market and they think they may reach out to you and say, you're infringing my patent, you can send a letter back and it says, well, hey, guess what? I have patents too, and I think you're using them. So it's this idea of building an offense and defense when you're going into a new business. You can also keep people out of your competition. You can license your patents, and that's what you hear about a lot, especially when it's a solo inventor or a small company, is that they'll do the work to come up with the invention, and then they'll license it to a larger corporation that can then turn that into a mass commercial product. And so I think, again, if you look at the Xerox example or the Murawski example that I mentioned before, where they were able to license all of those patents. And then ultimately, and this is what I do a lot of, patent litigation. Sometimes the cease and desist letters aren't enough and people won't agree to take a license. So you wind up filing suit or somebody files suit against you. And then it's also an asset for valuation, and you see this and you hear about it a lot of times with startups, Silicon Valley, that was a TV show where they take their patent portfolio and they pitch it, and hopefully you get people to invest in your company and in your ideas. So market share, company use their patent positions to protect or gain market share. An example of this is known as the smartphone wars. So there was a period of time about 10 years ago that just about every smartphone manufacturer was suing every other smartphone manufacturer, and a lot of it was over the same technology. So the fact that you have a camera in your phone was a huge issue for litigation. And then it would go from the fact that you have a camera in your phone to the fact that when I turn my phone, the picture turns with it. That's another lawsuit. The fact that I can zoom in on the photo I've taken, that's another lawsuit. And so what happened is basically, Apple and Motorola engaged in a lawsuit. Apple filed suit against BlackBerry, and then because Apple was filing suit against companies, they all filed suit against Apple. And there was really a 10-year period where there were just huge litigations going on all across the country over things that you think might be a nice feature of your smartphone, but not worth hundreds of millions of dollars, and employing whole law firms to work it out. But I disagree. I thought it was great. So in the past, you'd hear about patent monetization with these huge titans of industry where they would come in and have a massive portfolio because they could employ an entire R&D department to come up with new ideas. But now we're hearing a lot more about individual inventors, about startup companies, and you're also seeing companies that exist who now buy patent assets, and that's all they do. They're a non-practicing entity. It means they don't make anything, they don't sell any commercial products. Their whole business are patents. So they will either go out and buy patents, they'll buy patents from solo inventors, they'll buy patents from deceased inventors from their estates, they'll buy patents from companies that have gone out of business, and then they take that portfolio and they do what I described earlier. They'll send the letters to the big companies and say, hey, I have 50 patents and I think you're infringing 2 of them. Or they'll file suit, and sometimes, to be frank, sometimes they're right, and they do find, and there are companies that are infringing the patents they own, and they'll take it all the way through the end of the litigation. And other times, their claim may not be as credible, but a large corporation will pay them $20,000, $50,000, $100,000 just because they don't want to deal with the time and expense that a litigation would take. So there's just been a change in how patents are being used. You still have the large corporations getting patents and suing one another, but there's also a lot more openings and availability for smaller companies and for solo inventors to get patents and to monetize their patents too. So a little bit of what's going on today with medical patents and what are you hearing about in terms of current events. I think one of the big ones we're hearing about today is the battle over EpiPens. So I don't know, for me it's hard to get away from it every time I turn on the news. The original patents for EpiPens, and that's the pen with when you get stung by a bee or eat a peanut and you're allergic to it, you have to inject it to get your antihistamine immediately. The original patent was in 1977. And as I said, patents have a 20-year lifespan. So that means, I think we would have been looking at roughly 1996 for the expiration of the original EpiPen patent. And the ephedrine, the drug, is no longer patented. So it's just a question of the drug delivery device, the pen itself. But there have been a series of patents over the years that have improved the technology, and there are still current viable patents on the EpiPen, and that's what's currently owned today. And so with the EpiPen, let's see. So the EpiPen patent that's the cause of all the issues presently was obtained in 2004. And so it's an improvement on the original EpiPen. And so this patent went through quite a process where it went from the original inventor to Survival Technology to Merck, and then Mylan acquired Merck in 2007 and got the rights to the EpiPen. And so after Mylan acquired the rights to the EpiPen, the price for the EpiPen went from $94 to over $700. And that's because they are the only person that owns the rights to this technology now. You could go out and you could make the 1977 patent and nobody could stop you. But nobody wants the 1977 EpiPen. They want the 2004 EpiPen. They want the best EpiPen that's on the market. And so this has led to a lot of discussion about should we allow companies, and in this instance it's a medical device company, but you hear about it a lot of times in terms of how expensive drugs are, how much it costs to get potentially a life-saving drug. Should we allow companies to charge these prices when it means that people who need this and it's a potentially life-saving treatment for them may not be able to get that treatment? And to be frank, it's a question I don't have the answer to. I very strongly believe in the patent system. That's why I do what I do. But I do recognize that there are instances where the price of the product can prevent people from getting treatment and that it can be a barrier. It can be a barrier to access for life-saving treatments. And so this has been discussed a lot in Congress, and here we actually have a joint statement from both a Republican and a Democrat, and I think everybody knows how rare it is to get a joint statement on anything now, that they're concerned that the drastic price increases could have a serious effect on the health and well-being of everyday Americans. And so there is an allowed generic product. Teva can start to produce a generic for this, and the generic means that Teva went and said, we can build the same exact product. It's going to be the same product. It's going to work in the same way. We don't need to do medical testing on it because we're building the same product. The FDA approved Teva to start marketing that for 2018, and Teva said that they could produce the EpiPen for $300. So the question will be whether that can actually get through now the patent debate or the patent war, which Mylan sued Teva. So will Teva still continue to pursue the product? There are antitrust suits against Mylan right now over the pricing, and it goes beyond just the pricing issues. There's also insurance reimbursement issues tied in with a lawsuit as well. But it goes back to the original issue. We have the patent system, and it's supposed to promote new inventions and ideas. And developing a medical product, a device, or a pharmaceutical product takes millions of dollars. I mean, you do sometimes have the small company that's able to strike it right and come up with the right invention, and Murawski is an example of that. The first automatic external defibrillator, which is the defibrillator that hangs on the walls, there's probably one in this library, was established by a small company that was founded by 5 guys who quit their jobs at a big company, put their credit cards on the table, and went all in to try to do it. But most of the time when you're coming up with a new pharmaceutical product, you have hundreds, if not thousands, of failed attempts at that drug. You have to go through clinical trials and human trials that can take years, and again, just such a monetary investment to do it, that if you don't give the pharmaceutical companies and the medical device companies the incentive that, hey, you can have this technology for 20 years, it is yours alone for that time period, will they still be willing to make the same investment? Or will they take some of it and still make the same investment, but if a drug fails, will they continue to pursue new uses for a failed drug? AZT is an example of that. AZT is currently the treatment for AIDS. It was never intended to be a treatment for that. It was considered to be a failed drug until they started to test and see if it could be used in other branches. So if you took away the incentive from the medical device companies and the pharmaceutical companies, would you still see the same investment in research? So it's a question I don't have the answer to, but it's one that's certainly being debated now. And just one thing to bear in mind when you hear these stories on the news, your patent term is not the same thing as FDA exclusivity. So when you hear the term brand names and generics, oh, this is a generic of whatever the drug is, that means that the company has gone to the FDA and said, this product is exactly the same as that brand name product. I don't need to do clinical testing on it. I don't need to do human trials. It is the exact same product. So they have shortcut years of research, years of clinical testing, and the cost of the FDA application itself is significantly less. I mean, FDA applications can run in the hundreds of thousands of dollars to get FDA approval. So this reduces it greatly. But one of the things that you have to tell the FDA when you try to become a generic is that I don't infringe a valid patent. Now, you're probably infringing the patent because if you can tell the FDA, I have exactly the same product that works exactly the same way, it does exactly the same thing, and in fact, I've copied their formula, I'm pretty sure that they have a patent on it if it's a big company. But what the fight becomes over is, should that company have obtained a patent in the first place? Is it a valid patent? Was it truly something new? Did they make a significant invention that was large enough that they should be able to get that 20-year period of exclusivity? So the FDA actually has different periods of exclusivity where they will keep generic drugs off the market. That's set around anywhere from 5 to 12 years, depending upon the classification of the drug and how serious the disease is. So while we talk about patents preventing companies from coming out and producing similar products, the FDA actually allows generics onto the market into a shorter time period. You may still have a patent debate or a patent fight and wind up paying license fees, but generic companies can come out earlier than the patent term extension. So it's not all the patent's fault. One of the things that's being discussed as a potential solution for this is what's known as compulsory licensing, and that basically means that the government could put into effect a mandatory license. So if you come up with a valuable drug or medical device, and this is really the industry that they're talking about this, you can be forced to license it. So typically with a patent, I could come up with an invention and say, it's mine, you can't use it, nobody else can use it, even if I'm not using it. Under a compulsory licensing program, anybody can use it provided that they pay you a license fee. We do see this in other countries. It's used, for example, in India, has a compulsory licensing program on pharmaceuticals. It's currently being discussed here. I don't think it's going to really take off just because it's so contrary to what we hold for our patent system. And if you think about it, to a lot of the principles that underlie our sort of American legal system as a whole. We don't like to push people to do things that they don't want. We're a company that promotes the freedom of things. So we have, freedom of religion, freedom of speech. Other countries have freedom from. And the difference there, for example, is freedom of religion means you get to practice the religion of your choosing. Freedom from religion means that the state can't force you to practice a particular religion. So we tend to, just as a nation, believe in our freedoms, our rights. Patents are viewed as a property right, and I think we've all heard about cases where people have fought the federal government from taking their land. It's a similar idea with the patent system. This is my property. I earned it. Why should the government get to take it from me? So while compulsory licensing is being discussed, I just think it's so contrary to not just our patent system, but the principles that we have sort of across all of our rights, that I don't think it would go very far. Another proposed solution would be something similar to what we've seen in other countries with universal medical coverage. That's obviously a hot topic in Congress, and given the way our Congress works, not something I think would come to fruition anytime soon. But a lot of the discussion is, if the pharmaceutical products are this high, perhaps it can be resolved through the insurance companies and insurance reimbursements. If insurance companies only agree to pay so much money for a given product, a lot of times you see the price of that product coming down because then nobody else is going to buy it if the insurance companies don't pay for it. Okay. And this is just sort of a follow-up note on it. Even for pharmaceutical products that have generic products, you still see very, very high pricing for those generic products. So in this instance, there's no patent that's causing the price to be that high. And there are, in fact, class action lawsuits and litigations against some of the biggest generic companies, accusing them of committing a multi-billion-dollar fraud over generic products on diabetes, cancer, epilepsy, HIV, ADHD, and Teva, which is one of the largest generic manufacturers, raised prices on 112 different generic drugs from 2013 to 2015. Again, a lot of it comes down to supply and demand, but this certainly demonstrates that it's not just the patents that are driving the price of prescription drugs, and medical devices. Oops. And I will just like to note that our patent system generally allows for patenting improvements, even if they're just minor improvements. If you think about going to the hardware store and how many screws are available, probably each of those types of screws, whether it has a different thread, a different head, it has an anchor that pops out because it's a drywall screw, all of those are patented. And there's a lot of case law that I don't want to bore you with, but it essentially says that you can take things that were known, old elements, and if you put them together in a new way, that can be patentable. If you come up with a new use for an old product, that can be patentable. If you come up with a new way of making an old invention, that can be patentable. So we do have at the core of our patent system the idea that, not every invention needs to be the light bulb. Not every invention needs to be the defibrillator or the pacemaker. You can have minor improvements that are still to the betterment of society, and you're allowed to get a patent for that tiny bit of the improvement. Doesn't mean if I come up with a better case for a defibrillator that helps perhaps a child operate it because I've changed the buttons or something, that doesn't mean I get to keep people from using defibrillators. It just means you can't use my new buttons. And so this leads back to the discussion on the pharmaceutical products, and it's what's known as evergreening. So you'll have pharmaceutical companies and medical device companies that can start with an initial patent, and perhaps it's a patent on the drug, on the pharmaceutical product, and then they come up with a delivery device like the EpiPen, or if anybody's had a stent inserted in their heart to help keep blood clots out, some of the stents are actually covered with a drug, and the drug slowly dissolves in your system to help get rid of the plaque buildup as well. So that can be a separate patent. Or maybe they've tweaked the formulation just a little bit, but when you have this 20-year patent term and you have these follow-on patents, you can go from 20 years to 40 years, and that's what we've seen in the case of the EpiPens. And a lot of people argue that this is an improper use of the patent system, that you're expanding your rights beyond what's originally permitted, but people argue to the contrary, that allowing these types of patents does promote research and it does promote innovation. And again, AZT is an example of that because that was originally supposed to be a cancer drug and is now viewed as a life-saving drug for the treatment of AIDS. And had that follow-up research, the patent on the cancer treatment drug AZT had expired. Had the company not been able to get a patent for using AZT as an AIDS treatment drug, would they have even pursued the research to see if that failed drug actually worked for other treatments? And so that's the concern, that if you prohibit this type of patenting, that you won't have the same research in it and that you'll be blocking innovation. So there are some changes in the law recently in terms of patents, and this is going to be a bit of a deeper dive into some of the patent statutes that we've seen that have presented a hurdle to medical devices and medical technology. So if you remember at the beginning, I mentioned what can be patented. It's pretty much anything under the sun that man touches, other than when you go out and find a plant or a person themselves. And you have these three categories of what can't be patented. And it seems to make sense, right? I shouldn't be able to patent people. I shouldn't be able to patent parts of people or animals or plants that are found in the natural world. I shouldn't be able to patent abstract things like gravity. But what happens is it becomes this discussion of what's abstract. What's a natural phenomenon? How can I tell if something's truly natural or if it's man-made? And so, as always, the courts have gotten involved, and they've laid out it's a pretty complicated test, and it's complicated. I can tell you that we know it's complicated because if you go to a meeting of patent lawyers, and we were just talking about this earlier today in terms of some of the presentations at the PTO, you can't get away from these discussions. So what the Supreme Court did is they put together what they thought was a very clear two-step test to determine if something was patentable subject matter. So is it a process, machine, manufacture, or composition of matter? If it's not, well, you're out of the patent world anyway. If it is it directed to a natural phenomenon, a law of nature, or an abstract idea? If it's not, good, you can get a patent. But if it is, you could still get a patent if you're doing something significantly more with it. An example of that would be if I start with the abstract idea of a mathematical equation. I can't patent the equation itself, but am I using that equation in a software program, and that software program is now interfacing with hardware and doing something new with the hardware, that should be patentable. But that's not actually turned out to be the case. And so a big discussion that's happening now is what is abstract? Because we have this two-part test, but nobody knows how to apply it, and we wind up with constantly shifting results. So these are some examples of abstract ideas. Creating a contract, speed dating, a method for organizing speed dating was one that was thrown out as an abstract idea because it's just organizing human behavior, organizing information through mathematical modeling, processing information, managing a game of bingo is another example. So a lot of these tended to fall into the software side of the system. And then the question became the second step, what's significantly more? So are you improving the technology? Is there a practical application? And that's terminology that the Patent Office recently came out with. Is it directed to a practical application of this abstract idea? Are you doing something more than with what's already known in the field? And it just becomes a way to try to weigh out this test to see if something's abstract or directed to a law of nature. So we have all of these examples, and all of these cases keep coming out, but the problem is they keep coming out on opposite sides. And so where we're really seeing this is in the medical device technology that uses software. Because if you think about it, a lot of your sensing technology, a lot of your hardware is already known. I mean, defibrillators have been out for a long time, MRIs have been out for a long time, all of these things have been out for a long time, but we're not using the same MRI machine that came out in 1974. And a lot of what's new about this technology isn't the hardware, it's not the physical components, it's how you're using the physical components, it's the software that's running it. But a lot of times this software, that's the new part of it, is turning into the invention, and it's turning out to be not patentable. And so the FDA has recently recognized a new classification of medical devices, and that's software that's a medical device. And it defines software as a medical device. That software is intended to be used for one or more medical purposes that perform these purposes without being part of a hardware medical device. And I think the FDA recognized that this was a pretty cryptic definition because they actually provide examples for what is or is not a medical device on their website. And so some of the examples that they give about what software is a medical device includes allowing your software to assist, allowing your smartphone to assist with MRI imaging. Treatment planning software that supplies information that's used in a linear accelerator. And a linear accelerator is a massive piece of machinery that's used to deliver radiation therapy for cancer treatment. And you have a radiation source and you have a bed that the patient lies on, and both the radiation source and the bed move together in an effort to really just target the cancerous growth, as opposed to what you had in the past was this just sort of massive blast of radiation that would cover an entire area, and that's why people had such bad side effects from radiation treatment. And so the technology, the ability to deliver radiation and the ability to move a bed that a person was lying on was all known. So the new part of this invention was the treatment planning software that put all of the components together. And so the FDA is recognizing this as a new class of medical devices that you can receive FDA approval on, but that doesn't mean that you can get a patent on it, because a lot of this is falling into what the courts have deemed to be abstract. And so as our inventions are moving away from hardware, as we're seeing software at the core of more of our medical inventions, we're having issues obtaining patent protection for those. And I will say that the Patent Office recently issued guidance that helped swing the pendulum back and make it, if not easier, at least more clear about what was and was not abstract and what you could and could not get a patent on. The problem is that several of the courts have come out and said, well, that may be all very well and good that the Patent Office has done that, but we're not going to follow the Patent Office's guidance. So just because the Patent Office said you could get a patent on it doesn't mean that we agree. So we're sort of in this shifting sand situation where people aren't quite sure, now I have guidance on whether or not I can get a patent, but what good is it going to do me? If I have to go to court over it, am I just going to lose my patent there? And so this is actually something that's up in Congress now. They submitted a bill this week to try to get rid of these categories, get rid of the discussion of what's abstract, what's a natural phenomenon, all of it, and go back to the original system, which was essentially, did humans touch it? Did they change it? And if they changed it, then you should at least pass this first hurdle, which is it something that can be patented? We're also seeing under the same portion of the Patent Act, which was originally just something to say, is it a machine, a process, or a method of manufacture? It was supposed to be this really broad category that you could get patents under, and now it's being applied to medical diagnostic technologies because they're saying that a lot of the medical diagnostic technologies are natural phenomenon. And so in this instance, this is a Myriad case, they were able to discover the precise location and sequence of two human genes. I think they're referred to as the BRCA1 and BRCA2, and the mutations of these genes could substantially increase the risk of breast and ovarian cancer. And the ability to identify these isolated DNA segments was found to be not patentable. So it's considered a breakthrough in the field of cancer detection and cancer prediction, but because these genes were naturally occurring in the human body, they weren't able to get a patent on it. We've seen similar cases, and this is a case that came out somewhat recently called Ariosa, and this was the idea that the CFF DNA, which is that's the cell-free fetal DNA, that the ability to detect that floating freely in the mother's bloodstream is not patentable. And this is, again, a technology that's been considered groundbreaking. It allows you to make diagnoses way earlier based on your detection of this DNA, but because the DNA is naturally occurring in the maternal bloodstream, they consider it to be a natural phenomenon. And so merely detecting that in the bloodstream is not enough to get you a patent. And so what I find particularly interesting in this case is the court actually said that just because something is groundbreaking, innovative, or even a brilliant discovery does not mean that you can get a patent on it. And when I read those words, I think that that's the very opposite of what the patent system intended. And surely if something is groundbreaking, innovative, and a breakthrough, that's what our patent system should protect. And so we've had other cases that find the same thing. And essentially, if you're finding something that occurs naturally in the human body, and another example of this is how the human body reacts to a pharmaceutical product. If you have a better way of detecting the drug interactions or side effects, those have been found to be natural phenomenon as well. So we're seeing this shift away from the ability to get a patent in the medical field, and I think that's a lot of why this bill is proposed at Congress, because what was supposed to be just sort of a very broad part of the Patent Act, which says, hey, you can't go to another country, and if you think about when the Patent Act was first established in the 1950s, this makes sense. You can't go to a foreign country, to a remote location, and find a plant that nobody's heard of, and all of a sudden say, hey, I get a patent on this. That's what it was intended for, and now it's being used against software technology, it's being used against diagnostic technology that really are breakthroughs in the field, and it's being used to prevent or take away patents and prevent the ability to obtain a patent. So hopefully with the congressional bill, some of this will be resolved, or it'll continue to be fought out in the courts. And then a last area I want to touch on is just some of the issues that we're facing in medical technology for artificial intelligence. And a lot of that comes out of the fact that when all of our patent statutes were written, nobody thought about a machine that could think like a person. So the entire concept of personhood in our statutes is based on human beings being a person. In the United States, a corporation cannot be listed as an inventor on a patent application. You always have to have a human being identified as the inventor. European countries, other countries allow corporations to be listed as inventors, but not here. So our entire Patent Act is written from the perspective of a human being. The inventor has to be a human being. The owners can be a corporation, but ownership flows from inventorship. The question of whether something is new and non-obvious, all of that is done from the perspective of what do people working in the field think about it? What would people working in the field know? And then our question of infringement, who is liable for actions that infringe somebody's patents? All of that is predicated on the idea that people are performing the actions and that people are making the inventions. So going back to the question of who invents, we now have technology that is making the next leap forward by itself. We are getting to the point where we have software that is writing new software for its own uses. They saw, I think it was, I can't remember if it was Google or IBM, that basically they allowed artificial intelligence machines to interface, and they wound up coming up with their own language because they felt that the known languages that humans used were too inefficient. And this is not out of a movie. That's true, that the machines came up with their own languages to communicate with one another that were more efficient than human speech. So we are approaching a point that the artificial intelligence could be making that next leap forward as it's coming up with the new source code, but AI can't be named as an inventor right now. And so the idea for inventorship is each person must contribute to the conception of the invention, and in order to have an invention, it has to be a definite and permanent idea of the complete and operative invention. And the problem is if you have a programmer who's writing source code, and maybe they're writing source code for a medical product or something else, but the artificial intelligence is the one that finishes writing the code. The artificial intelligence is the one that makes the next step. Who is the inventor? And we have these requirements of awareness as well, but when you have the artificial intelligence being the one that's taking the inventive step or writing the code, can you say that the artificial intelligence is aware of its own invention? I don't think we're there quite yet. Maybe we will be someday. But this is all coming out of the question of who is the inventor and the fact that our whole legal model is based on human beings being the actor, which in fairness did make sense up until recently. So this leads to questions like you have a medical device company who comes up with a new idea. Gosh, it'd be really great if we could get software to do this. An example would be, we're training our imaging processing software to recognize cancer. And we're going to teach it what cancer looks like, and then it can take new images and diagnose that cancer. And then you have a software company that develops it. So who's the owner there? And if it's the device itself, maybe the software recognizes that there's a new way to perform that diagnosis. Maybe it puts some sort of grid down over the image and performs some sort of equation to figure out whether something's cancerous. Who owns the invention? Who made the invention? And another issue that we're seeing a lot here is where you have hospitals that are working with medical device companies, and the hospitals are providing patient data to train the device. So in the example I just gave you, those images of what is and is not cancer, that would come from a hospital. A doctor or a medical facility would have the patient records. They, I'm assuming, remove all of the patient private information and just send the information of the images and then the diagnosis. Well, that's obviously valuable information for the hospital to have, but if you give it to the medical device company and they suddenly get a breakthrough product and then you wind up walking away from your joint development agreement, who owns that product? Who owns the new technology? If you take the data out of the machine, you can't unlearn the artificial intelligence. And so now people are suggesting that if companies go into business together like that, they're going to have to start taking essentially snapshots of the software. If you have company A and company B, and they walk away from an agreement, and then the thought is that you could go back to, I'm going to force company A to go back to the software that we had 5 years ago. And maybe you have that written out in an agreement, but how are you going to prove it? And so this is part of the issue that's facing the artificial intelligence when you're using all of this data to grow. And it does also start to touch into the issues of privacy and data issues because, I've talked with some of the engineers and in particular professors that are working with students, and the students are super excited, and not so much in the medical field, but one example was a student had come up with an idea where they could go through Yelp, social accounts, all publicly available sources, and go through and pool all the data and then try to predict where people would move and what type of apartments would most interest them based on the data that was available using artificial intelligence. And obviously that could be very valuable. If you think about apartments.com or rent.com, they'd want to know where certain people are moving, what type of apartments they're interested in. The problem is it is illegal to use your data like that. So it becomes this line of what happens with the data, what happens with the technology, and how do the companies use it. And the question of inventorship is great. I'm sure, to have your name on a patent would be wonderful, but where the money comes in is if you are named as the inventor on the patent, you have an ownership right in that patent. So if you are the sole inventor on the patent, you are the sole owner. If you are a joint inventor, then both you and your co-inventor have equal rights to that patent, which means that you can both make, use, sell, offer for sale that invention, and you can both license that invention to other people. So you can imagine the scenarios I talked about a moment ago where you've got a hospital, a medical device company, a software company. All of them are going to want to have ownership rights in that technology, so it all boils down to who is listed as an inventor on it. And again, right now, we can't name the machine itself as the inventor, so who came up with the idea that drove the machine? Who taught the machine? Who made it possible? And this we see a lot as well in research and development, R&D environments. We have, especially in a lot of our universities and our medical hospitals, they have R&D departments and innovation departments, but they're not necessarily going out and manufacturing products. They're doing research. And so the big question is who is going to own that technology as well? And so one thing to be aware of, especially if you're working for a large company, check your employment agreement. A lot of employment agreements will state that you have basically automatically assigned away all intellectual property rights for anything that you come up with while working at that company. And then some states will actually have laws that regulate that one way or the other. Some states will find that even if you have that clause in your contract, you cannot be forced to assign away your rights. And then other states find that by working for that company and using their resources, you have implicitly given away your rights to the invention. But as a lawyer, my advice is always read the contract, read the fine lines, read the fine print. But it's something that we're seeing more and more in the legal world. And so just touching on the concept of new and non-obvious again, our whole system is based on would it be obvious to a person of skill in the field. But who is this person now when you have artificial intelligence that's capable of scanning through databases? I mean, there are databases that have every single patent in the entire world entered into them. There are pharmaceutical databases that have every known product, every known pharmaceutical product, every known chemical composition and combination of chemical compositions. And there are artificial intelligence now that are capable of scanning through that and recognizing what technologies are present, what your keywords are, what the most likely search results are going to be. So if you now have all of this technology available at your resources, I think it's going to raise the bar on whether or not something's obvious. I mean, if I could find the answer by running a search in a database in 30 seconds, it's going to be a lot harder for you to say to the patent examiner, well, no, this isn't obvious, and it took me 10 years to come up with this answer. Is somebody that doesn't have access to that database that's working as a solo inventor going to be disadvantaged because the standard's now going to be the larger companies that have access to this technology? So these are all issues that the Patent Office is talking about now. They had a conference recently, a whole day symposium where they addressed the issue of artificial intelligence and how they should start to handle it as it becomes more prevalent. And it's something that other patent offices across the world are dealing with as well. And it's not really something that's been addressed yet. And I think that's in part because our technology is just reaching this point, but I think it's going to be more and more of an issue going forward. And one of the last questions is who infringes? So if somebody owns a patent, if one of you owned a patent, and I made what your patent covers, I've infringed it. Now, you may have artificial intelligence that are making things without your knowledge. An example is in the pharmaceutical space, they're looking at having artificial intelligence that can run through, you've got your database of known chemical compounds, and they're putting together artificial intelligence that can identify the most likely compound to treat a given disease and also identify what the side effects are. And in some of those instances, they're looking at developing technology that can identify maybe your top 5 best candidates, and then they're going to synthesize that product and start testing it. Well, if your artificial intelligence selects a chemical compound that somebody else has patented, you could have infringed the patent without even knowing it. If somebody else has a patent that's directed to software doing something, perhaps signal processing or something's happening in the software, and your AI writes the code and you don't know what the AI is doing, you could have infringed somebody's patent without even knowing it. So we have this concept of personal responsibility in the United States that artificial intelligence throws a monkey wrench into. And we've seen a discussion in Europe, in the European parliamentary system about this, not necessarily with respect to the patent system, but what if the artificial intelligence causes an accident? A bunch of companies are developing self-driving cars, and a lot of that's being run by the software. What if the self-driving car runs a red light and causes a traffic accident? Who do you sue? Was somebody negligent? Was somebody reckless? Was it the person who built the car? Was it the person who wrote the program? Was it the person who trained the program? Or was it just a glitch? Things happen in mechanics. So we're going from this concept of personal liability and personal responsibility to what happens when the machine does it, and we don't really have answers for that yet. And so this is just the statute on setting out what I just said. Whoever makes, uses, sells without permission has violated a patent. And again, this was based on the concept of human beings taking the actions. So I think that we've already walked through this hypothetical about it where we have essentially an AI application that's taking the infringing step and the company doesn't even know it. So who will be deemed to have controlled the AI and who will ultimately be found liable for those actions? And then lastly, that we do have some cases that basically suggest that if you control the technology that infringes, you can be found to be the infringer. So even if you don't intend for the infringement to happen, even if you didn't know it was infringing, if you're directing or controlling the technology or somebody else's performance, you can be held liable for those actions, which means you could probably be held liable for the AI's actions as well. And this is again here where somebody who is just collecting information or data from a system that infringed was found to infringe as well because they were making use of the infringing system. And if you think about a lot of what our AI is doing, that's using the data to obtain the results. So if you're using the data, if a hospital is using the data, they could be found to infringe as well under some of our existing case law. So with that, we've gone a little bit through the past, present, and future of medical patents. I'd like to thank everybody again for their attention and to the Carlson Center for having me and to Jennifer for reaching out to me. But does anybody have any questions?
Hi, I do have a question.
Yes.
So this pertains to indications for pharmaceuticals and how important that is in terms of IP. So looking at like Wellbutrin, they saw people didn't smoke as much, and then they say, okay, now we're going to call it Chantix, and it's the exact same thing, but they've rebranded. And can they get a patent because the indication has changed?
Yes, if you can identify it as a new method of use for an old product, you can get a patent on that. That is within the wheelhouse of what can be patented. And so an example of that was similar to the AZT, which was originally developed as a cancer drug, failed as a cancer drug. The patent expired for the cancer drug aspect of it, and they were still able to get the patent protection, rebranded it AZT, and were able to get the patent protection for the method of treating AIDS and HIV.
Who else has questions? Kate's going to walk around.
Actually, tying into Jen's question, if you were the Chantix person in her example, would you have to wait for the drug you're taking but changing the way it works? Would you have to wait for that patent to expire before you? Yes, that's my question.
So is the idea like, if there's an existing patent out there, do I have to wait for the patent to expire to get a new patent on sort of a new use for it or something? Yes. So you don't. And if it's your patent, it's the easiest way to go about it, because if it's your patent, you can file another application. You're the sole owner or inventor of all these ideas, so that's easy. But even if it's not yours, if you went from Wellbutrin to Chantix, you can patent an invention that involves somebody else's technology, and you can get a patent for it. The issue is, can you use your patent without infringing that other person's technology? So, I could get a patent on that new use, but if if I had to make the drug, and by making the drug I infringe somebody else's patent, I may have a patent, but I'd still infringe your patent every time I made it. But a lot of times what you see in that situation is somebody would obtain the patent and go back to the original company and say, hey, by the way, I came up with this idea, I have a patent on it, and I think you can make a lot of money on it. Why don't we have a license agreement? Why don't I sell you my patent? So all patents do is they allow you to prevent other people from using your ideas. They do not give you a right necessarily to use your idea as well. And that may be, if something's prohibited by the FDA, you might be able to get a patent on it, but if the FDA doesn't grant you approval, you can't sell it as a pharmaceutical product or a medical device in this country just because you have a patent.
Troy, just 1 second.
Does everything have to prove that it works? Or like the lady, she made a patent that was a piece of junk.
Yeah, you don't have to make it yourself, and you don't even necessarily have to prove that you have made it. But
it's fraud. It doesn't work.
Well, in her instance, it was fraud because she was telling everybody that she could make it and that they had made it. But in order to get a patent, you just need to provide enough information in the document that somebody could make it, even if you haven't done it. So that's sort of the test is, can somebody else read what you've put in your patent and make and use that invention as well?
So I could say I invented a cancer drug, but I don't have to prove it works.
Well, what you would have to do, though, is put enough information in your patent application that somebody else could make that drug that you say you've invented, and that they would be able to use it to treat cancer. So one of the things we always talk about in sort of the terms of patent law is, a flying car. I could say, sure, I'd love to have a patent on a flying car, and wouldn't that be cool? But until I can actually tell people how to build a flying car, I probably can't get a patent on it. Sure. Is there another question here?
That was my question.
Okay.
I thought it was.
So you know how the Apple Watch can take an EKG? Is that a separate patent than an actual EKG?
I think for Apple it is, because they're putting out patents using their own sensing technology, and a lot of it comes down to the individual sensors that are used in their watches. So that's why you see a lot of times, everybody talks about their proprietary heart monitoring systems. So TomTom has it, Garmin, Apple, Fitbit, just about everyone has one. My guess is that they've probably developed similar but different technology. And because there's that underlying, the old patents that are directed to heart rate technology and heart rate sensing, they're probably very minor improvement patents in a way. You have to use this one specific piece of hardware in this specific configuration, and that's what Apple has a patent on. So if TomTom uses one other piece of hardware, they can probably avoid the patent. But we are also expecting a lot of lawsuits to come out of this sort of merging of the fitness world and the medical world and all the other spaces.
Going back to evergreening, you have the initial patent on the composition of the drug or something, and then additional, or rather secondary patents on delivery mechanisms and so forth. What prevents a generic developer from just practicing the initial patent that has just expired or something like that and competing with the delivery mechanism, which may be an incremental improvement?
Really nothing. The issue is, though, people and certainly physicians in hospitals want what's new and what's deemed to be the best. So you could go back to the original patent, you could go back to the original product, but people don't necessarily want to do that, especially if there's become a reputation that this is the best technology, this is the newest technology. You know, a hospital's not going to want to say, well, that's all right, we'll use the third best technology, it's okay. Right, correct. And that's the thing, you could make that original EpiPen and you could sell it and use it. I mean, the original patent for insulin, I think, was in the 1920s, but obviously there are still active patents today on insulin because it's not the same insulin formulation and it's not the same method of producing that insulin. And so I'm sure over the years there are probably dozens of patents that have expired on insulin and you could use any one of them, but people don't want the old methods. Yeah, a lot of it is marketing. I mean, some of it is, you know, from what I understand about the EpiPen, the current version is significantly better than the original one, and I think it's about the accuracy of delivering it and, you know, how it actually gets the injection into your skin and the fact that you don't have to be as precise with it. So I think with the original one, if you didn't sort of stab it in quite the right way, you could miss the dose. But, you know, are there non-patented iterations of it that somebody could come up with? Probably.
Going back to your insulin question, so how do the insulin manufacturers, my friend worked for Pfizer for a very long time, insulin's naturally occurring, so how do they get around that, you know, it's naturally occurring in your body to patent it?
So a lot of the insulin that they're doing now is a man-made insulin, and it's used as a replacement. So the man-made insulin is not necessarily identical to the insulin that your body produces. I think it's supposed to mimic it, but it's not, because it's man-made and it's made out of the chemical process, it's not identical to the body's version of it. And a lot of what the patent is directed to is the method of making the insulin as well.
Any other questions?
If it was identical, could they still get a method of making?
They could get a method of making it. They could not get the actual, I think they couldn't get the actual insulin itself. Because if you come up with, you know, some new machinery that does it 10 times faster, I think you could probably get a patent on that machinery, but you probably couldn't get a patent on the underlying, like, drug or insulin in that instance.
Thank you.
Anyone else for questions? All right, well, let's thank Susan for her wonderful presentation.
Thank you again for having me.
And I do want to remind you guys, thank you so much for coming today, to please fill out those evaluation forms. And I think that's it for today. I really appreciate all of you being here. And we're going to be leaving. Once you leave these doors, you'll head out the door kind of right behind us here. So that's the door that'll get you out of the building tonight, since we are actually closed. So thank you.